TNT Limitation Section 230 to 238, the provisions of the Indian Limitation Act 1908 shall, so far as they are not inconsistent with this Act, apply to all suits, appeals and application under this Act, Section 230. All suits and application instituted under this Act for which no period limitation is provided elsewhere in this Act shall be instituted and introduced respectively within 1 year from the date of occurring of the cause of the action. Suits of the ejectment of occupancy of Rayyat or a non-occupancy Rayyat on any ground mentioned in Section 22, Section 41 shall be instituted within 2 years from the date of misuse, Section 233. Now, applications for recovery of possession of a holding or any portions thereof from which an occupancy Rayyat has been unlawfully ejected must be instituted within 3 years from the date of such ejectment. Suits or applications by a village headman for recovery of possession of his office or agricultural land against a landlord or any person holding by virtue of any assignment of the landlord must be instituted within 3 years from the date of dispossession. Now, Chapter 18, Special Provisions with respect to Mundari Khot Khatidars. Such of preceding sections that are applicable to Mundari Khot Khatidars shall in their application to such persons and their tenancies be read subject to the provision of the following section in this chapter, that is Section 239. Now, Section 240, Restrictions on transfer of Mundari Khot Khatidar tenancies. No Mundari Khot Khatidar tenancy or portions thereof shall be transferable by sale in execution of a decree or court or order of a court. However, when an order has been made by any court for sale of tenancy or portion thereof in satisfaction of a debt under a mortgage other than unsuffictory mortgage that was registered before the commencement of the Chota Nagpur Tenancy Act 1908, the sale may be made with the provisions previous sanction of Deputy Commissioner. Now, if the Deputy Commissioner refuses to sanction the sale of any tenancy or portion thereof under the provision to subsection 1, he shall attach the land and make such arrangements as he may consider suitable for liquidating the debt. A mortgage of a Mundari Khot Khatidar tenancy or any portion thereof shall not be valid, but a Bhugat Bandha mortgage for a period not exceeding 7 years shall be valid. However, a Mundari Khot Khatidar tenant may transfer by simple mortgage his rights in this tenancy or any portion thereof with a view to raising loan for agricultural purpose to a bank registered under Bihar and Orissa Cooperative Societies Act 1935. No lease of a Mundari Khot Khatidar tenancy except on any portion thereof shall be valid except Mundari leases of uncultivated land when granted to Mundari or a group of Mundaris for the purpose of cultivation or when granted to a Mundari cultivator to enable him to cultivate the land as Rayyat. When a Mundari Khot Khatidar tenancy is held by a group of Mundari Khot Khatidars, no Bhugat Bandha mortgage or Mukhari lease of tenancy or any portion thereof shall be valid unless it is made with the consent of all Mundari Khot Khatidars. No transfer of a Mundari Khot Khatidar tenancy or any portion thereof or by any contract made otherwise than the provisions in the foregoing subsection shall be valid. Nothing in the foregoing subsection shall affect any sale except as declared in the proviso to subsection 1, any mortgage or any lease made before the commencement of Chota Nagpur Tenancy Act 1908. Section 241, Transfer for certain purposes. Notwithstanding anything contained in Section 240, a Mundari Khot Khatidar may without the consent of his landlord transfer the land comprised in his tenancy for any reasonable and sufficient purpose having relation to the good of the tenancy of the tenure or state in which it is comprised, such as use of any land for charitable, religious, educational purpose or for purpose of manufacture or irrigation. However, the transfer shall be made by registered deed and written consent of the Deputy Commissioner shall be obtained for the same. Before consenting to any such transfer, the Deputy Commissioner shall satisfy himself that adequate compensation is tendered to the landlord and other co-sharers in the tenancy for loss caused to them by the transfer. Any appeal against any order of a Deputy Commissioner consenting or refusing to the consent of any such transfer shall be made as per proviso in Chapter 16. If any person obtains possession of Munderi Khut Khatidar tenancy or any portion thereof, contravention of provision of Section 240, the Deputy Commissioner may eject him therefrom. This is Section 242. The rent of a Munderi Khut Khatidar tenancy may be enhanced by an order of Deputy Commissioner only if the tenancy was created just 12 years before the presentation of petition for enhancement. However, the rent of any such tenancy shall not be enhanced to an amount that would exceed one half of the rent that would be payable for the land if it were held by a Rayyat having a right of occupancy therein. When an arrear of rent occurs in respect of a Munderi Khut Khatidar tenancy for which a record of rights have been prepared, no suit shall be maintainable in any court in respect of the same. However, the landlord may apply in writing to Deputy Commissioner and a certificate shall be signed authorizing recovery with simple interest not exceeding 12.5% per annum. This is Section 244. If in the course of proceedings under Section 244 any question is raised which could, in the opinion of Deputy Commissioner, be more properly determined by a civil court, the Deputy Commissioner shall refer the such question to civil court in the district. This is Section 245. A landlord may institute a suit for recovery of arrears if record of right is not available in respect of the same, where a Munderi Khut Khatidar tenancy is held jointly by a group of Khut Khatidars and an objection is made making of a certificate under Section 244 to the execution thereof to the maintenance of a suit under Section 246. On the ground that all Khut Khatidars have not been made party to the proceeding, the objection shall not be entertained. Where a certificate under Bihar and Odisha Public Demands Recovery Act 1914 has been made against a Khut Khatidar for any money due to government for rent to a landlord, the Deputy Commissioner may attach the land occupied by him. Recovery of contributions from co-sharer tenants. When a Munderi Khut Khatidar has paid the rent of his tenancy, including portions thereof due from his co-sharers or any of them, the said portions may be recovered by him with interest as if they were arrear rent due to a landlord. Now all Munderi Khut Khatidar tenancies shall be described in record of rights prepared under Chapter 12. No suit shall be entertained under Section 87 for any disputes regarding any entry relating to Munderi Khut Khatidar tenancy in a record of rights, Section 251. At any time within 3 months from the date of final publication of record of rights, a suit may be instituted before a revenue officer for decision of any dispute regarding the entry of Munderi Khut Khatidar tenancy or any incident thereof in the record. An appeal may be made in prescribed manner and to a prescribed officer against any decision of a revenue officer under Section 252. This is Section 253, where when the revenue officer has finally decided a suit instituted under Section 252, the decision shall be considered as part of relevant record of rights. When an order has been issued under the Bengal Tenancy Act 1885 in respect of any local area, estate or tenure, any claim that made such an area, estate or tenure, or is not Munderi Khut Khatidar shall not be taken as evidence in inquiry made by revenue officer for taking a decision on suit. Now, supplemental provisions, Chapter 19, Section 257 to 271. Joint landlords. When two or more persons are joint landlords, anything that a landlord is expected to do must be done by both and or all those persons acting together. No suit shall be entertained to change, modify, or set aside any decision of a Deputy Commissioner or Revenue Officer in suits under Section 20, 32, 35, 42, 46, 49, 50, 54, 61, 63, 65, 73, 74, 75, 85, 86, 87, 89, or 91, or under Chapter 13, 14, 15, 16, or 18. Section 258. The state government may make rules to carry out the object of this Act. Section 264. The state government may make rules for regulating the procedure of Deputy Commissioner in matters under this Act for which a procedure is not provided herein. In performance of his duties and exercise of their powers, Deputy Commissioner shall be subject to the general direction and control of the Commissioner and of the boards. Nothing in this Act shall affect the powers of duties of settlement officers as defined by any law not expressly repealed by this Act. Now, important facts: Section 46, 47, 48, 48A, 49 of Chapter 8, Section 470, 71A, 71B of Chapter 10, and Section 240, 241, and 242 of Chapter 18 have been included in the 9th Schedule of Indian Constitution through 66th Amendment during the year 1990. After inclusion in the 9th Schedule, only Parliament is capable of making amendments to the same. The judiciary would not interfere in the same. Till date, 26 amendments have been introduced in this Act. The last amendment was brought in the year 1995. One of the important amendments was CNT Amendment Act of 1947 that substituted Section 46 that makes transfer of a tribal land to any non-tribal invalid. This is Section 46. During the year 1962, the government of Bihar again amended Section 46 to make it legal for persons belonging to scheduled castes and backward classes, in addition to scheduled tribes, to transfer land to a person belonging to the related castes. Now, Section 49 of this Act permits all kind of lands, including tribal land, to be transferred for industrial, mining and ancillary purposes. The state government has, during 2016, proposed an amendment to Section 49 of this Act, according to which the government may acquire land for purposes like basic infrastructure, railway, transmission line, in addition to industrial and mining projects. Section 71A of this Act provides for restoration of land to a tribal transferor in case of a transfer of tribal land to a non-tribal transferee. Land related to Bundu Sun Temple and Apollo hospitals have been restored as per provisions of Section 71A. As per provisions of Section 71A, lands belonging to a person from scheduled tribes were being transferred to persons not belonging to scheduled tribes through SAR court with help of compensation. The government has made provisions in this amendment proposed during 2016 to prevent any transfer of land belonging to a member of scheduled tribe to those not belonging to scheduled tribes based on compensation. Additionally, it provides for institution of a suit for restoration of land in SAR court. Now, Section 241 of this Act permits transfer of land under Munderi Khut Khatidar under some special circumstances, though this necessarily requires prior permission of Deputy Commissioner. Provision for restoration of land under Munderi Khut Khatidar has been made under Section 242. Section 21 of this Act is quite significant. This permits any Raiyat to use the land in any manner that is authorized by local customs or usage. If the land fit for agriculture undergoes change in character because of the usage, the Raiyat may face ejection from the same. Of late, tribal society has been seen evolution of a class of people who do not want to use their land for agricultural purpose as per the immediate need. It has been decided to allow a landlord the right to change the nature of his land as per proposed amendment of 2016 brought by the state government. This would allow any landholder to use his agricultural land for commercial purposes. It would be possible to construct house, shop over such lands. After Arjun Munda government was formed in the state in the year 2010, instructions were issued for strict implementation for Section 46 for restoration of land under this Act. The ruler of Honorable Jharkhand High Court passed on 25th of January 2012 made a prior permission from the Deputy Commissioner compulsory for transfer of lands belonging to backward classes and scheduled castes. This badly impacted the real estate business running in the state. Section 46 does not permit a lease of more than 5 years from tribal land. Hence, it becomes difficult to avail loans from banks against such tribal lands. At present, some 20,000 suits relating to this are pending in the courts. It emerged clearly after a survey of tribal conducted by the Government of India during 2001 that despite existence of this act, a number of transfer of land has been made around towns like Ranchi, Jamshedpur, Gumla, Lower Dhaka by members of the tribal community. The Tenancy Act in present form was introduced to define relationship between landlords and Raiyat. These are provisions in the Act for resolution of issues like recovery of rent, determination of rent, arrears of rent, etc. The Deputy Commissioner has been entrusted with all powers by keeping him as the focal point under this Act. However, after abolition of landlordism, the government itself has assumed the role of landlord. As a result, the interest of government and Raiyats have often been found to compete against each other. In the changing context, several new kind of issues are coping up with regards to revenue courts, revenue officers, problems of tenants, classification of land, usage of land, transformation in rural society, etc. Resolution for these issues are not available under the Tenancy Act in the current form. It is necessary to define clearly the roles of Revenue Court and a revenue officer in new form. Necessary amendments are also required in legal provisions relating to classification of land and usability of land. The need of the hour is to bring in an amendment that may pay for the development of Jharkhand state while also keeping the tribal interest intact. That'll be all for CNT. We'll be proceeding with Santhal Pargana Tenancy Supplementary Provision Act of 1946 in the next video.